We're good to go. Hello, everyone. I appreciate you coming today. It's our third event for the year. We have the pleasure of having Clark Neily from the Institute for Justice come out today. The Institute for Justice is a nonprofit public policy firm based out of Washington, D.C. And Clark is the director of their Center for Judicial Engagement, has argued numerous times for the Supreme Court, specializes, again, in judicial engagement and really works to challenge the unconstitutional expansion of government by articulating a principled vision of judicial review. I think you'll enjoy his talk tonight. Great experience and a great speaker. So, Clark, welcome to the stage.
Thank you. Thanks for having me down. I appreciate you taking the time out of your day to show up for the event. Judicial engagement is probably a somewhat esoteric sounding subject. It's an invented term. We had to invent the term judicial engagement because of a problem, or at least what I think is a problem in modern constitutional law, and that is the prevalence of fake judging, judicial abdication. Basically, it's my position that in most areas of constitutional law, the Supreme Court's not even trying to get it right. Basically, the process of adjudication is either a truth-seeking process or it's not. If it's not a truth-seeking process, it's not adjudication. And in the vast majority of areas of constitutional law, the way the courts go about deciding constitutional cases does not involve any truth-seeking function whatsoever. It's basically a collaboration between the judiciary and the other branches of government to basically find a way to say yes to government. That's my thesis. That's the thesis of the book that I wrote. I'm a libertarian. I really love the Constitution, and so you can probably imagine this doesn't sit too well with me. And I want to basically take maybe the next 20 or 25 minutes to try to convince you that really is going on, that is an objectively accurate description of modern constitutional law, that is, that courts aren't even trying to get it right, and then leave it to you to decide whether you think that is a desirable or reputable or defensible way of doing constitutional law. Obviously, I have my own feelings about it. Those will probably come through as I share my thoughts with you. But really, my main goal is not so much to convince you that this is a problem, but really just to hopefully accurately describe to you what modern constitutional law really is. Before I jump in, I want to dispel something that's a kind of a myth that gets perpetrated by people who don't like the idea of meaningful judicial review. And that is that it is impossible to know what the government's doing in any given case. They have this idea of the government as some impenetrable black box, and it's inconceivable that we could really know what the government is up to. There's, sometimes hundreds of legislators vote for a law, and then that law is implemented by armies of bureaucrats and law enforcement officers. You just really can't know what the government's up to. That's crap. That is just absolutely false. For example, we know that in part because we don't treat any other corporate body that way. The federal government routinely accuses corporations of doing things that require some knowledge of the mindset of the organization. They've accused corporations of conspiracy, of discrimination, all kinds of other crimes and misconduct that require some sort of an insight into what the person is thinking or doing, or not just doing, but thinking. So anyway, when the shoe is on the other foot and we're asking what is the government up to, I reject the idea that it's impossible to know, or I should say that it's categorically impossible to know. There are certainly some cases where it may be impossible, or it's too close of a call to make a determination. But the idea that it is categorically impossible to know what the government is up to is utterly false. And it really matters, actually, because if you don't ask that question, you can't do constitutional law. And let me try to illustrate that. Is anybody aware of the fact that about a year and a half ago, Boston police went from house to house in certain neighborhoods outside of Boston and ordered people to stay indoors until further notice without a warrant? You know that? Yeah. So to me, it matters why they did that. Do you know why they did it?
Was that in search of the bomber?
Yeah, so there had been a bombing at the Boston Marathon at the finish line, killed 3 people. And then the perpetrators of that bombing, that turned out to be 2 brothers, had murdered a police officer at MIT and taken his gun. And the police basically managed to narrow the search down a few days later, determined that they were probably in a particular neighborhood, and they went around to homes in that neighborhood and ordered people to stay inside. Now, to me, and to my knowledge, nobody challenged that, even though it was done without a warrant or any sort of intercession by courts. I think probably the reason for that is everybody understood that under the circumstances, that was a perfectly legitimate thing for the police to do. Why? Because they were trying to protect people's safety. There were armed terrorists in the neighborhood, so it's safer to be inside. And they were also trying to facilitate the immediate capture of these terrorists by keeping people off the street so they could search for them. Now, imagine that instead of a bombing and police in pursuit of terrorist suspects, instead there had been no bombing, and there was an election the next day. And it turned out the only neighborhoods this was going on in were neighborhoods that had a record of voting for the party that was not in power. This looks rather different, doesn't it, from a constitutional standpoint? Exhibit A, trying to protect people from bombers. That looks like one thing. Exhibit B, trying to rig an election or to throw an election. That looks like something else. That's a very basic point. It's simple, I hope, and it's just as simple in any other constitutional setting. If you do not ask why the government is doing what it's doing, you cannot do constitutional law. And in the vast majority of constitutional cases, the Supreme Court doesn't ask what the government is doing. It doesn't care what the government is doing. It makes no effort to determine what the government is really doing. Instead, the whole process of adjudication is just a charade, so that you can have the appearance of judicial review without any of the substance, and the court can just reach the predetermined conclusion that whatever the government is doing is constitutional. That is modern constitutional law, from my perspective. I've been doing it for 15 years. The Institute for Justice, where I work, is the nation's premier libertarian public interest law firm. We are also the only libertarian public interest law firm, so it's pretty easy to be premier. So I litigate in areas, I sometimes refer to them as the forgotten constitutional rights, property rights, economic liberty, meaning the right to earn a living in the occupation of your choice. We work in areas of free speech that the ACLU doesn't care for very much, or doesn't care as much about, so like commercial speech, for example. Let's do a quick thing on con law before I dive in. Does anybody know what I did here? I mean, let me just ask, how many of you had con law or took it, are taking it? Most of you? Okay. Does anybody know what this is? Really quick? Yeah, so these are the tiers of scrutiny that you're probably taught in your con law class. You got strict scrutiny up here, meaning the government has to have a really good reason for infringing on somebody's liberty or treating people differently. Intermediate scrutiny is next, and then rational basis review. And you're probably taught that the curve is something like this. This is sort of the curve of diminishing judicial review, but it just sort of slopes down like this. Remember that for the exam. Remember that for the bar exam, and then discard it. It has nothing to do with real life. This is what it looks like here. Does anybody know what the T line is that I put off to the right there? Were you taught what the T line is? That's the truth line. And everything in a rational basis case is below the truth line because it has nothing to do with the truth. The government is actually invited by the court to come into court and lie about what it's really doing, and then rewarded for doing so by having its policies upheld, even if they are justified on the basis of assertions that are demonstrably false. That is, to me, the heart of modern constitutional law. Because why? Because the rational basis test, believe it or not, is the default setting in constitutional cases today. You only get heightened scrutiny. That's what these two are referred to together, heightened scrutiny. I would also, by the way, add one more. There's a fictitious standard of review called the rational basis test with teeth. It's not the rational basis test. How do you know? Because it has teeth. It's a form of heightened scrutiny, and which basically is just a euphemism for genuine or any scrutiny. So if you're above the truth line, in other words, if the court is actually trying to figure out what's going on, then you have heightened scrutiny, which I would just call scrutiny. And then if it's below the truth line, you have rational basis review, which again is just a charade and a fraud invented by the Supreme Court to enable the government to misrepresent its true ends and get away with it. Let's take a historical example. So I mentioned earlier that I work in, I do economic liberty cases to challenge the government when it's trying to prevent somebody from earning a living in the occupation of their choice for illegitimate reasons. One of the earliest, well, let me start with this one actually. So the first occupational licensing case that got to the Supreme Court, or at least that I'm aware of, was an 1873 case involving a group of people in Illinois who wanted to practice law, but they were forbidden from doing so. Does anybody know what this group was? It was women. Women wanted to practice law in Illinois. They couldn't because there was a state law that prohibited it, and a woman named Myra Bradwell moved to Illinois from Vermont, where she had been practicing law, because Vermont did allow women to be lawyers. And when she tried to be admitted to the Illinois bar, they said no, because we have a law that prohibits that. And there are basically two reasons the state gave. One is that women should be home having babies and raising them. And second, that in the presence of a judge, women become so emotional and incapable of rational thought that they just can't practice law. So the first point is kind of hopefully a quaint anachronism. But let me ask you to focus on the second point really quick. That is an empirical assertion, isn't it? And if we cared, we could check. We could actually look and determine whether it is in fact the case that women become so emotional in the presence of a judge that they cannot practice law. I will tell you, I've been litigating for 20 years. That has not been my experience. Maybe it's just a run of bad luck that I've encountered all these strange women litigators who seem able actually to function in court. I suspect not. But the point is this. If we cared, we could ask, and we could check. So let me give you another example of a historical case. There was one of the first sort of discernibly rational basis tests. They didn't use the terminology back then, but they took the same approach that courts do now, so you know it was a rational basis case, even if they didn't call it that. Involved a humble household product that I suspect some of you may even have in your refrigerators that used to be illegal to sell in many states, and under federal law it was illegal to ship in interstate commerce. Anybody know what it is? It was back in the late 1800s. In the late 1800s, a French chemist invented margarine. And when margarine showed up in America, a particular industry freaked out. Which industry would this be? The dairy industry. That's right, because they did not want to compete with cheaper margarine. So they did what industries or professions do when faced with new competition. They ran off to their state legislatures and got laws on the books that basically impeded in all kinds of exotic and interesting ways the ability to sell margarine. One of my favorite is, I guess in its natural state, margarine is this really kind of bright, striking white color. And one law was required that you had to mix pink dye into the margarine so it would look gross and people wouldn't want to use it. But some states just went the whole hog and actually made it illegal to sell margarine, including Pennsylvania. And that law was challenged by two guys who were convicted of selling margarine illegally in Pennsylvania, and it went up to the U.S. Supreme Court. And it went up in a really interesting posture, or at least it's interesting for the purposes that I'm talking to you about today, and that is this. It went up, and basically what happened was when these guys were charged, they offered to prove through expert testimony that the state's asserted justification for banning margarine was factually false. The state's justification is that margarine is deadly poison. And they offered essentially to prove that that's not true, and so there's no rational basis for the law. It's just a complete, I mean, it is what it is. It's a nakedly anti-competitive law that has no connection whatsoever to advancing any discernible public policy. It's all about shutting down the margarine guys. They offered to prove that. And the trial court actually excluded that evidence, didn't even want to hear it. And that shows you what's really going on here, right? Because imagine the legislature had said something like, well, margarine turns you into witches. Everybody knows that. Presumably, the court would have then said the same thing. Well, I don't know. Who knows? That's up to the legislature. And that's precisely what the majority said. Once the legislature says something, it doesn't matter if it's true or false. If they say women can't practice law, so be it. If they say margarine turns you into a werewolf or is deadly poison, so be it. It's none of our business. And that's the difference between real and fake judging. That's the difference between what I call judicial engagement, which is where you actually try to get at the truth, and judicial abdication, where you simply rubber stamp whatever the government's doing. And that's the fundamental tension in constitutional law today. Real judging and fake judging. Or maybe I should go over here. Real judging and fake judging. Real judging is the exception, fake judging is the rule. The default setting in constitutional cases today is rational basis review. It is a fraud and a charade. In order to get heightened scrutiny, and I always kind of hiccup when I say the word heightened scrutiny, because heightened really doesn't mean anything in that sentence other than just real. To get real scrutiny, you have to convince the court that you're dealing with a right that the court considers to be fundamental, which is very few. Supreme Court doesn't particularly like fundamental rights because they actually have to do real work. They actually have to get at the truth of what's going on. And so they've limited your fundamental rights to a fairly small handful. Let me give you an example of a couple of rights the Supreme Court considers to be non-fundamental. I already mentioned one. It's your ability to earn a living. I find that incredible. I mean, if you look back through the history of this country or just look inside your own soul and ask you kind of what are some of the most important rights that you could imagine, I would say that earning a living would be very near the top. Putting food on your family's table. And by the way, for those of you who haven't had a career yet, nothing you do in life, except maybe getting married and having kids, is going to more influence who you are as a person than what you do for a living. Because you're going to put a lot of energy into it. And if you're lucky, like me, you'll actually get to choose something that you care about. My sister's a doctor in Maine. She cares about that. I think she gets a lot of gratification from helping people have babies. I get a lot of gratification from suing bureaucrats. But whatever it is, there's probably something out there for you, or at least I hope there is. And the idea that the government should basically be the gatekeeper to your pursuit of happiness, which is in large measure what Thomas Jefferson was referring to in that passage of the Declaration of Independence, I think is quite shocking. Quick little factoid. In the 1950s, only 5% of the American workforce was subject to occupational licensing. Today, it's 29% and climbing. So about 1 in 3 Americans can only earn a living with permission from the government. Is that power abused? You better believe it. Is it abused the way it was in Illinois when they wouldn't let women practice law? You better believe it. Is it abused the way it was when Pennsylvania prohibited people from selling margarine? You better believe it. And so when you have a judiciary that is completely checked out, as ours is, it's a real problem. And let me illustrate that for you. This is, well, actually, let me do one thing first, just to sort of drive home what it looks like when the court is engaged versus not engaged. So I'm into coconut water, like nature's Gatorade. Maybe I'm weird. Anyway, imagine two different kinds of laws relating to coconut water. One makes it illegal to advertise coconut water. You can sell it, but you can't advertise it. The other one makes it illegal to sell coconut water, period. Can't even sell it. Okay, so the first one, the advertising restriction, would get a form of heightened or meaningful scrutiny, intermediate scrutiny, called the Central Hudson Test for commercial speech. Basically, the Supreme Court still considers speech, even advertising, commercial speech, to be a fundamental right, so you get meaningful judicial review. Selling the same product, of course, is a much less important right. According to the Supreme Court, advertising a product is super important, but selling it is unimportant. I think we can all agree with that. Anyway, so if you're trying to challenge the advertising ban, here's what that looks like in court, and I've done both. If you challenge the advertising ban, the first thing the judge says to the government lawyer is, what's the problem? Why are you restricting people's ability to advertise this product? And the government has to do something quite extraordinary at this point, which is tell the truth. And that is quite extraordinary in constitutional law. They actually have to give an honest explanation for the regulation, which is, again, the exception. And they have to say something like, well, it turns out actually the coconut water is very high in sodium. It's got a lot more sugar than people expect, so they're getting duped, and that's the problem. And then they would have to prove that with evidence. And if they couldn't prove it, then the law would be struck down. The next thing the judge would say is, do you have any evidence that the restriction that you've chosen actually advances your stated interest in protecting public health? And again, the government would have to have some evidence that it does, and if the government doesn't have that evidence, the law is struck down. The last thing the judge would say is, isn't there some less restrictive approach that you could have taken? I mean, cigarettes are really dangerous, and we still allow people to advertise those, but there's been some restriction. You can't use Joe Camel. You have to make certain disclosures. Couldn't you have done that with the coconut water? And the government would have to have some evidence why that wouldn't have worked. That's real judging or judicial engagement. The hallmarks of real judging or judicial engagement are a genuine quest for the truth by a neutral adjudicator on the basis of evidence. That's all it is. Genuine quest for the truth by a neutral adjudicator on the basis of evidence. All right, let's look at the rational basis case. That has none of those features. In a rational basis challenge, because you're only trying to sell a product, which is unimportant, not advertise it. When you're trying to sell a product, and that has been banned, margarine, coconut water, whatever it might be, the first thing the judge says to the government lawyer is roughly, look, for God's sake, don't tell me why you passed this law. I don't want to know, because that would be embarrassing. Instead, I would like you to try to make up a reason why you might have passed the law. It doesn't have to be true, and it can be completely pretextual and insincere. Just make something up. Don't put me in the position of having to actually grade the legislature's homework in here. I want you to make something up. And so the government lawyer will put on his thinking cap or her thinking cap and just make something up. And the Supreme Court, and by the way, this is not a caricature. I'm not exaggerating. The Supreme Court has repeatedly held that under rational basis review, the legislature's actual ends are irrelevant. Unlike in an advertising case, the government need not support its factual assertions with evidence. Speculation and conjecture is perfectly fine, or as the Supreme Court calls it, rational speculation, perfectly fine. You don't need any evidence. And then here's a really crazy part. If the government lawyer is insufficiently creative to invent a justification for the law, guess who has to help? The judge. The judge actually has to help make up justifications to help bail out the government. And that's how you know, or that's one of the ways you know, there's no real judging going on. As most of you probably know, a bedrock requirement of due process is a neutral adjudicator, and the judge is definitely not neutral in a rational basis case because the judge has been assigned to help one side win. And I'm not saying they do it very much. It's usually not necessary. The government lawyer is usually creative enough to just make something up, and that's basically how it goes. Let me give you a real-life example. To my knowledge, no one has yet banned coconut water, so that is still a hypothetical. But I'll share with you the most ridiculous occupational licensing law that I've ever challenged. And that's the way you do it, by the way. If you're trying to win a rational basis case, you have to find the most ridiculous example of government regulation that you can, because otherwise the judge isn't even going to pay attention to you. In fact, that actually happened to me one time. I had an economic liberty case in state court in Texas where I used to practice. And I put on what I thought was a very interesting and entertaining witness that all had to do with horses, and he actually had a horse skull and some equipment that he was using. I thought it was a pretty interesting presentation. I looked up at one point, and the judge was actually engrossed with the computer monitor on his desk. And I thought at one point he might be following the transcript. Some people just take in information better when it's written. Thought he was doing that. And I asked the court reporter during a break, and she said, no, he's just surfing the net. Okay, great. So anyway, that's what you're up against. And so you have to find the most ridiculous law that you can in order to have any chance of winning under rational basis review. And the most ridiculous occupational licensing law I ever found was in Louisiana, which is perhaps not surprising. where you have to be a license to be a florist. I have to have a license to be a florist. So those of you who are going to practice law, you have to get a license to do that. I mentioned my sister's a doctor. She has to have a license to do that. In Louisiana, you have to have a government license to be a florist. So if you take 2 flowers and put them together in an aesthetically appealing way, that's a floral arrangement. It's illegal to sell that in Louisiana without government permission. No kidding. Okay, so does anyone want to play the game? The game is make up an explanation for that. I will just tell you, I'll kill the suspense. That law was passed for the same reason that the law banning women lawyers and bartering was passed. It's totally about suppressing competition. But let's put that aside. Fortunately, it's a rational basis case, so the truth doesn't matter. Anybody want to make up an explanation? Why? What could you say? What could you picture yourself saying with a straight face in court if you represent Louisiana and you got to just make something up for why they might have passed this law? Anybody? You're going to kick yourself, I'm going to tell you, because the judge upheld it, of course. Judge rubber stamped it. All right. One of the things he cited was the physical dangers of unlicensed floristry. These include misplaced corsage pins. You would have gotten that if you thought about it. Infected dirt. And my favorite, because it's so visual, exploding bridal bouquets. I mean, not literally exploding. They're not munitions, but a bridal bouquet is a bunch of flowers held together at the stems with floral wire. And you wrap it up real tight and then cover it with tape. And when I was deposing a representative of the Louisiana Horticulture Commission, a.k.a. the Floral Police, there actually is such a thing. And I was asking everybody, as I was questioning them, well, what do you think the law might do to benefit the public? And his explanation was, well, a bridal bouquet, as I just explained, is held together with floral wire. And if that wasn't done properly, then the whole thing could just come unsprung. And you'd have this giant ball of unsprung wire, and then the bride could trip in that and do a faceplant on her wedding day. And, query, as long as the truth doesn't matter, which the Supreme Court has made clear it doesn't, is that a rational basis, or is it just too silly? And it was really fun, actually, watching my opposing counsel in this case kind of wrestle with that question, because every once in a while, the physical dangers of unlicensed floristry point would creep into their briefs, and then an argument they would kind of disavow it because it was too embarrassing to say in open court. But actually, the judge did pick up on that, and among the justifications he gave for upholding law were all of the things I just mentioned: infected dirt, misplaced corsage pins, and exploding bridal bouquets. And it's humorous, I think. I think it's humorous on one level. It's not so humorous on another level, and I'll just quickly share with you the not humorous side of the story. Our lead client in that case was a woman named Sandy Meadows. Sandy was a high school dropout from Mississippi who was living in Baton Rouge, and she was a widow. And when her husband died, they didn't have any money in the bank, so she had to support herself. And it turns out she had only one vocational skill, which was arranging flowers. But she hadn't been able to pass Louisiana's licensing exam because, to put it into one word, it's rigged. To get a florist license in Louisiana, you have to take 2 tests, or you did at the time. They've since tinkered with the statute, but you had to take 2 tests. One was a rinky-dink true-false test. Nobody really had any problem with that. And second, you had to do a practical exam where you do 4 floral arrangements in 4 hours, and then you bring them up to a table where they would be judged by a panel of judges. And you got to hand it to Louisiana. These judges were not theoretically disinterested bureaucrats. They would bring in working florists from the industry to decide if your work was good enough to compete with them. Anybody want to guess what they usually said? No. We actually got the data going back on the test. The pass rate in the exam for the 10 years before we filed suit was 37%. Louisiana bar exam was 68%. So it's twice as hard to be a florist in Louisiana as it was to be a lawyer. And it's no accident, of course, because the point of the law is to suppress competition. That's the point of the law, and it was working very effectively. Okay, so Sandy's problem was that she couldn't pass the exam, but she nevertheless bravely worked in the Louisiana black market for floral arrangements for a number of years until the Horticulture Commission caught on to her, showed up at the grocery store where she was managing the floral department and said, "We're going to shut you down if you don't bring in a state licensed florist." The problem is they only needed one florist at the grocery store, so they hired a state licensed florist and fired Sandy because she didn't have a license and couldn't get one. And she was a good florist. It wasn't, that test is really rigged. I studied it, I questioned people who administered it. It's a rigged test. So the fact she couldn't pass it doesn't mean she wasn't a good florist. She was hired by a grocery store to run the floral department. She was good. Anyway, so I flew down to Baton Rouge one day, early September. I think it was 2003, and I was going to prep her for her deposition. She was going to be questioned in the case by the state's lawyers. And I went to pick her up at her kind of crummy apartment. She was on the 2nd floor. I walked up the stairs. I come out of the stairwell, and there's Sandy lying on a couch in the common area of her apartment building. It's really hot. It's like 95 degrees, almost 100% humidity, just miserable. And she's lying there with a neighbor fanning her with a piece of cardboard. And Sandy's just gotten out of the hospital where she had gallbladder surgery, so she's got surgical staples from here to here. It was just pathetic. And I looked down at her and I said, what are you doing? And she said, well, they turned off the power in my apartment because I can't pay my utility bill, and so I have no air conditioning. They're working on the water main outside, so I got no water, and this is as comfortable as I can get. I put her in the rental car and took her to a grocery store where you could write a check, get her power turned on, checked her into a La Quinta motor inn so she could have some comfort and air conditioning. And I said, no, we're not doing this deposition. You're not in any frame of mind. And I went back to Washington, D.C. That was the last time I saw Sandy Meadows alive. She died 3 weeks later, alone, unemployed, and in poverty, because the state of Louisiana passed a law saying she couldn't do the one thing she was able to do to put food on her table, and a federal judge didn't think it was worth finding out what the real reason for that law was. Probably tell from the tone of my voice, I disagree with that decision. I carry that loss with me. I think we should have won that case. I think the right to earn a living is important. I think all constitutional rights are important. I don't think there's a single constitutional right that is so unimportant that the judiciary should abandon the truth-seeking function when it comes to challenging that right in court. And I hope I convinced you of that too. Thank you.
Thank you, Clark. Professor Stacy, as many of you probably have had as a professor here, has graciously agreed to give commentary today. He graduated from the University of Michigan School of Law. He was a clerk at the U.S. Court of Appeals, and a whole bunch of other neat things in Washington, D.C., and he's an illustrious professor here at KU Law. Welcome, Professor Stacy.
So I'd like to congratulate Mr. Neily on his success in the Heller case. That's a nice feather in your cap. For your very readable and thought-provoking book, which I read yesterday, and for your willingness to challenge the conventional wisdom on both the right and the left. And thank you for your entertaining remarks here. My role is kind of a hired gadfly, so let me get to it. Pretty much all of us can agree that it's the obligation of the courts to enforce the Constitution, and insofar as they don't do so, they are abdicating their responsibility. But the $60,000 question, of course, is what does the Constitution mean? And Mr. Neily says that he doesn't think that courts are even trying to get it right, and I guess I have a much more charitable view of the judiciary. I think they are trying to get it right, they just have a different view, a non-libertarian view of what the Constitution means. So Mr. Neily is upset that cases involving unenumerated property rights fall below the truth line, and cases involving federalism fall below the truth line. So his proposal is that we have to have active judging everywhere and always. These cases should be put above the truth line, heightened degree of scrutiny. But I guess in my view, a decision to put cases below the truth line, and these are most cases involving federalism, and cases involving unenumerated economic liberties, reflects a judgment that the Constitution really doesn't have much to say in this area. And instead, really, people ought to go to the political process. So Mr. Neily takes a libertarian view of the Constitution. And because courts don't enforce a libertarian reading of the Constitution, they're abdicating their responsibility. I think that essentially calls for a return to the Lochner Court. So the Lochner Court took a very narrow view of Congress's authority to regulate under the Commerce Clause. It read an unenumerated right of freedom of contract into the Due Process Clause, which made really regulation of economic life of every sort presumptively unconstitutional. What to make of that? Well, the first thing, upon reading Mr. Neely's book, it seems to me that mainstream constitutionalism, which takes a broad view of Congress's authority to regulate under the Commerce Clause, and doesn't recognize unenumerated property rights, is kind of dismissed out of hand as a self-evidently incorrect view of what the Constitution means. And I don't think that's right. Take federalism, for instance. In the late 18th century, it was possible to give Congress authority to address national economic problems while leaving a very significant sphere of regulatory authority exclusively to the states. But, we don't live in Williamsburg, colonial Williamsburg, right? We live in a thoroughly integrated national economic world. So if you look around the room, I challenge you to identify anything in this room that was produced wholly in the state of Kansas. So the challenge in today's economic world is to resolve the conflict between giving Congress authority to address national economic problems on the one hand and leaving exclusive regulatory authority to the states on the other. Reading Mr. Neely's book, I think he takes the position that the justices who voted to uphold Obamacare as an exercise of Congress's constitutional authority to regulate interstate commerce were just wrong. We can dismiss that as an unreasonable reading of the Constitution out of hand. I don't think so. Healthcare accounts for 17% of the national economy. It's an important aspect of our international competitiveness. And wherever one draws the line, it seems to me that authority to regulate healthcare would fall on the side of Congress's authority to regulate interstate commerce. At the very least, that's a reasonable view. And it's also a reasonable view that it's up to Congress, not the courts, to determine whether to implement the universal access to healthcare that every other country with a pulse has via an individual mandate or an employer mandate. Okay, now take individual rights. The Lochner Court did what Mr. Neily urges. Why is the Lochner Court's view widely regarded as discredited? Well, because it was used to invalidate legislation aimed at protecting those who are vulnerable in the marketplace. Women, workers, children. And this legislation, much of this legislation had the effect of enhancing liberty. And it's perverse to interpret the liberty protections in the Constitution to preclude the adoption of legislation that enhances the liberty of women, children, workers. Okay, so it seems to me that a libertarian reading of the Constitution stands in need of a justification. Does he offer one? And the justification I see is that courts shouldn't rely on the political process because the political process is inherently flawed. Special economic interest groups have undue power, and therefore there's a need for judicial protection. Good justification or not. The first thing to notice is that it doesn't justify taking a narrow view of Congress's authority at all, because the federal political process suffers from the exact same defect as do the state political processes. What about individual rights? Well, there's an element of circularity to the logic here. So why is it that legislatures respond unduly to special economic interest groups? Right? Campaign contributions, spending in the political process. That's why they curry favor with special interest groups. Well, that is in part a product of a libertarian view of freedom of speech. The court's money is politics jurisprudence is based on, a libertarian idea of people have a right to spend money in the political process, and that equality is not a justification that supports limiting the role of money in the political process. So the argument is that we need to adopt a libertarian view of the Constitution to cure defects in the political process that are partly the result of a libertarian reading of the Constitution. So I'm convinced.
Clark, if you'd like, you can have a few minutes to respond.
I want to thank Professor Stacy for a really interesting and enlightening response. One of my favorite things about going and giving talks like this is to learn, where I might have had some holes in my argument or receive further assurance that I didn't have any holes in my hair. No, I don't know. Look, let me just make one point. I made a really startling accusation, which is that in the vast majority of constitutional cases, the courts are perpetrating a fraud. And that, I don't think that was really rebutted. I didn't offer a libertarian reading of the Constitution. That's a different talk. What I did was take the Supreme Court at its word. The Supreme Court has held for over 100 years that you all have a right to earn a living in the occupation of your choice, subject only to reasonable government regulation. So I'm taking the Supreme Court at its word and asking if it is enforcing that constitutional right that it recognized. It's not a libertarian reading of the Constitution. The Supreme Court recognized that right, and I'm asking, is the court treating that right with seriousness, or is there some kind of a bait and switch going on here? And self-evidently, it's a bait and switch. They're saying, oh yeah, no, you have a right to do this thing, but when you come into court, it'll be wink, wink, nod, nod the whole time, because there won't be any real judging going on. That's what I object to. Everything I talked to you about was process. Everything I talked to you about was the approach that judges take to judging. I didn't talk to you about theory. I didn't talk to you about a libertarian constitution. Certainly we could have that discussion. All I did was take the Supreme Court at its word. And the Supreme Court has said, for example, yes, you have a right to earn a living, a constitutional right to earn a living, but they have rendered it meaningless by assigning to it a fraudulent standard of review. The Supreme Court has said you have a right to own property, not have that property bulldozed, just so some other person can take it and build a nicer house. That right has been sandbagged. Now, the Supreme Court didn't do the honest thing, or what I think would have been the honest thing, and said, you know what, we've been wrong for 100 years. You don't have a right to own a home, and you don't have a right to earn a living. We were wrong. That would be honest. I would disagree with it, but at least it would be honest. And the Supreme Court would have to pay whatever institutional price might come with making such a startling assertion about America, that you actually don't even have a right of economic freedom or property rights. But at least it would be honest. Instead, what the Supreme Court does is a bait and switch. Yes, you have a right to earn a living, but when you come into court, the whole thing will be a charade. That's what I object to. I think that's wrong. I think it's indefensible. I guess I'll just stop by asking one question. Was anybody born in Kansas here? Were your parents living in Kansas at the time? Yeah, so I guess there's something in the room that was produced wholly in Kansas.
Well, if we have questions, hopefully Professor Stacy and Clark Neily will be able to answer them for you guys. So, does anybody have any questions?
I was just wondering how you would respond to Professor Stacy's point about political process and rational basis being important to allowing the legislative process to take control.
That is an argument, and I guess I would say that it's true up to a point. There is certainly room for the political process to make policy, but there are limits, and the limits are provided in the Constitution. Next to slavery and Jim Crow, I think probably the third or fourth most immoral thing that America ever did was a widely popular policy called eugenics. Are you familiar with it? We sterilized about 60,000 people in this country in the 20th century, and that was a democratically approved policy. At one time, where there were 31 states, more than a majority of states, had eugenics laws on the books at one time or another. And the first time that issue got to the U.S. Supreme Court in the 1927 case called Buck v. Bell, the Supreme Court basically followed that approach. Well, there's nothing in the Constitution about not being sterilized, so we'll leave it to the political process. You can see from that case how horrifying that can be. I'm not saying it is always horrifying. I'm saying it can be horrifying if we too lightly say that basically anything not specifically mentioned in the text of the Constitution gets left up to the political process. That has turned out horribly for at least some people in this country. I'm not saying it always does, but I'm saying the Supreme Court has a job that has been assigned to it by the Constitution to police those boundaries. And we can certainly disagree where those boundaries are. My position is simply that when the Supreme Court has said that a particular area, like occupational licensing, is subject to some constitutional limitations, I object to a judicial process that is a charade when it comes to something the Supreme Court has said we have a right to do. But thanks for the question. It's a good question. Yeah.
You, when you opened, brought up a very interesting comparison between, police power in terms of terrorism and police power in terms of rigging an election.
Yeah.
So it led me to believe, because I have a great interest in voter ID laws and what your position is on voter ID laws. Do you consider them to be a constitutionally protected right?
I'll be honest with you, it's not an area that I work in. I haven't spent a lot of time thinking about it, so I would say that my opinion on this would be not of much substance. I think they are subject to abuse, no question about that. And so I think the courts should be on guard in terms of determining whether a law is functioning in such a way that it is being abused, trying to suppress certain people from voting. No question in my mind that these laws have been used that way. On the other hand, I think the concerns on the other side are not, one cannot simply dismiss, or I think one should not simply dismiss the concerns that people on the other side have, which is that there's got to be some way to make sure that people are not engaging in voter fraud, because that happens. There's a lot of debate about whether it's ever happened here, but let's be honest, it has happened somewhere at some time. I mean, I'm from Texas, where LBJ came from. Everybody knows how he got elected to the House, I believe. Anyway, so I think it's a very difficult issue, and what I would say is this. In an area like that, if it's a close call, I have no problem with the courts leading it to the legislature, but I want the courts at least making some effort to police the boundaries on either side and not playing a game, which is what I think they're doing in the rational basis cases. So that would be an area of law where I would say, listen, as long as you made a real effort, however you come down, I think really could depend just on your perception of what the underlying facts are, and those could vary from case to case. It's probably not a super satisfying
Well,
answer.
yeah,
but,
I just know that they used to be associated with property rights specifically.
Yeah.
Like if you don't have property,
Yep.
you can't vote.
Yeah, and that's right. And we've moved on. I think we appreciate the importance of voting now in a way that we didn't before, but not everybody has come as far as we would like on that, I'm sure. I saw a hand over there. Did I? I did not. Maybe? All right, anybody else? Yeah.
In response to Professor Stacy, I think you said that you weren't arguing for a libertarian reading of the Constitution, but just taking the Supreme Court at its word as to what are the substantive rights in the Constitution. And one of them you pointed to was occupational liberty rights to earn a living.
Right.
And just as a non-constitutional law person, I would be interested to know what era, what year you're referring to, how far back you have to go to find the Supreme Court endorsing that right, and I guess basically the question would be, what's the content of that right? Because I think you really need to know the content of the right in order to assess the discussion you and Tom Stacy were having about what's process and what's substance.
Great question. I appreciate it. So we know in 1873 that the Supreme Court did not recognize a constitutional right to earn a living. How do we know that? Two cases. One was called Slaughterhouse, where a bunch of butchers were essentially put out of business. Well, technically they were required to work for another company, in essence. And we know that the Supreme Court didn't particularly care that women couldn't be lawyers in Illinois. So we know that they didn't care about occupational freedom at that time. And then somewhere basically between there and 1905, which is when the Lochner case was, they started caring. And one could probably pick any number of cases as a sort of a beginning point, but it was somewhere in there, I would say. And then during the basically following Lochner, well, actually, a case that comes to my mind is the Yik Wo case. This was a case involving a San Francisco ordinance that said you had to have a special license if you operated a laundry that was made out of wood instead of brick or stone. And it was portrayed as a safety measure because wooden laundries burn up, and San Francisco also burnt up at one point after the fact. But what turned out to be the case and the California Supreme Court rubber stamped the law on that basis. The Supreme Court actually looked behind the asserted justification to determine a really important fact, and that is every single white person, except for one, who applied for an exception, got it. And every single Chinese person who applied for an exception didn't get it. That law had nothing to do with protecting the public from fire. It had everything to do with putting Chinese laundries out of business. That's an example, I would say, of the Supreme Court caring about occupational freedom. It is also an equal protection case. They did also focus on the racial animus. But there's language in there that indicates an awareness of and importance of economic liberty. And so I would say that's a case, and that was, I think, 1890 something. So it was going on at some point just before the turn of the century. As for the parameters of it, I mean, it's a challenging question, but keep in mind, it's a challenging question in every area of constitutional law. I mean, the First Amendment is about as clear as it gets, Congress shall make no law abridging the freedom of speech, and we have an not endless, but almost endless amount of First Amendment jurisprudence. Is burning a flag speech or conduct? Computer code, is that speech? All kinds of interesting and challenging questions. And so here, I think the easiest or maybe the most simple way to put it would be that the government has to be pursuing a plausibly public purpose when it regulates your occupational freedom. And I would say that those cases will fall into three categories. Louisiana Flowers and Margarine, totally preposterous to suggest that they're following a discernibly public purpose. At the other end, licensing doctors, I think that's perfectly plausible that they're pursuing a public purpose. And then there'll be some cases in the middle. But there's a whole lot of cases that are really easy to resolve, like Margarine, like women lawyers, like Flores. So that would be, is that enough of an answer?
Well, I guess what I was listening for was anything since 1937 where the Supreme Court says there is a right to earn a living. I didn't hear
Oh, okay, yeah.
It makes me wonder if it's really about substance, not process.
It depends what posture you bring it up in. So, for example, if you're trying to go shrimping in South Carolina, but you happen to be from North Carolina, they're really, really concerned with your ability to earn a living because it comes up under a different part of the Constitution, Article 4's Privileges and Immunities Clause. That's an actual case, by the way. South Carolina was charging non-resident shrimpers something like 100 times more for a shrimp license than in-state residents. So it was clearly discriminatory. There's a provision of the Constitution that the Supreme Court understands to speak to that issue, and they honed right in on the importance of the ability to earn a living. It just happens that it came up in a setting where they could care about it. And then if you turn the constitutional compass about 2 degrees to one side or the other, they don't care about it anymore. But there's been a consistent track record of, another example, in the 1950s, there was a guy who wasn't permitted to practice law in New Mexico because he had once been a member of the Communist Party. Boom, the Supreme Court was right there to protect him. And so it's very sporadic, there's no principle to it whatsoever, and you might as well be throwing darts at a dartboard when it comes to occupational freedom in the Supreme Court. That would actually be a best case scenario, not best case, but it would be better than what they're doing now, which is totally disingenuous, in my view. Anybody else? Okay. Well, thank you so much. I appreciate the opportunity.